In today's economy, more people than ever are looking to buy and sell businesses. But how do you do it? Welcome to the Deal Board, presented by Transworld Business Advisors. Straight talk about real deals and real people. Listen to stories, interviews, and expert advice to help your business sale, merger, or acquisition process. Now, here are your business exit experts, Andy and Jessica.
Welcome back, everybody. And today, for our episode, we're going to talk about legal issues when selling your business and what to know legally about when you're buying or selling a business. Legal is a big component when you're doing these transactions, and having the right legal partner is crucial. We've talked about it a lot. And today we have two great legal partners on the podcast to talk about their expertise and what to expect in a deal.
A legal partner is essential in a deal. A lot of times when we're doing deals, we talk about the deal killers and what kills a deal. And the wrong attorney could absolutely at least delay a deal and cost you a lot of money because they don't exactly know what they're doing or they need to learn what they're doing on your dime. But they could actually kill the deal. And they could be asking for unreasonable things in a deal that don't belong there just because of their inexperience or they're over. Listen, attorneys are not risk takers, right? So they're going to do everything they can to not have their client take risk, which is part of their job, but there's a balance there, right?
Right. And what we've talked about too is there's specialists. So just like doctors, there's specialists in law. And in this segment of law, there's transactional attorneys, and all they do for a living is help people in buy-sell transactions. So they know which of those risks are normal, which are abnormal, and can kind of guide you through the process. We have two experts on the show today. I interviewed Jonathan Langer with Izbiky and Associates out in Colorado. They do about 100 deals a year in the small to mid-sized business transaction size, which is great because we talk about a lot too is when you're selecting the right attorney, if you can select somebody who has experience, think about all the risks and issues they've already navigated and all the kind of issues that they can solve for your deal. And then, Andy, you have a great interview too.
I do. I have Deborah Carman of Carman Law, and she has been with us for, probably 20 years. She probably doesn't want to talk about it, about how long she's been doing deals with us. And she is great. I mean, just talk about the nuts and bolts of buying a business. And one of my biggest points to buyers and sellers who say, do I really need an attorney to sell your business? On the sell side, you want an attorney to make sure that everything that you signed up for as a owner of a business is now the buyer's problem. You're transferring those assets properly to the buyer. And then on the buy side, you want to make sure that you have properly transferred those assets to you legally.
Right. And there's some representations and warranties that you're going to want included on both sides to make it clear that the buyer understands what was presented to them during the conversations about the deal, and the seller understands what they've presented to the buyer. It is one of those things where people will ask me, can I do a deal without an attorney? And I say, you can do a deal without an attorney. It's not something I'd recommend. It's probably my number one deal team member that you have to have, even above a broker. It's just, there's a lot of moving pieces in a deal. And even like you said, Andy, transferring assets properly, if there's a seller note, filing proper liens against the company for the seller to give them a little bit of protection. It's not as easy as just drawing up a sale contract.
Yeah, or the landlord, making sure that you properly transfer the lease, and most sellers are going to have to stay on the lease, and you're going to want to have a hold harmless against that, and you're going to want to have a collateral assignment of the lease if you're the seller. So if the buyer doesn't pay the note, that you have that you get the lease because the landlord could just take it from you. I mean, there's things that you want in a deal that you don't even think about that you want to make sure that you have the proper legal structure. And then you just talk about the buyer having the right structure in a corporation, S Corp, LLC, all those kind of things. The CPA might give you some advice there as well, but just making sure you have the proper structure going into a deal.
So we're not attorneys at all, but we work with a lot of attorneys. We have two of the best that we work with that are providing some great advice today. And also, I think this is something too. Hiring an attorney for your deal is not a giant expense, especially when you look at the potential repercussions. So if you're in the middle of a deal, you're considering buying or selling, being properly represented, selecting an attorney that has deal experience for the certain size companies that you're about to sell or buy is crucial. But Deborah and Jonathan both provide some great insight. We'll also have their contact information in the show notes if you have further questions for them today.
Yeah, this is so worth listening to. If you're going to buy or sell a business, this is one of those episodes you definitely want to tune into. So let's get started.
Let's get to it.
Transworld Business Advisors is the world's largest business brokerage and mergers and acquisitions firm with over 500 brokers in nearly 200 offices worldwide. Transworld's team handles thousands of business sales every year. To be connected with a qualified business broker or learn more about the buying and selling process, visit tworld.com/the deal board or call 888-719-9098.
Welcome back, everybody. And today, as you know, we're talking about what you should legally know about selling your business. And we've already dove into the sell side a little bit. So now we're going to talk about if you're buying a business, what are some legal things that you need to know or legal opportunities you have? And I have a great partner of ours, Jonathan Langer. He is a partner at Izbiky and Associates in Colorado. They do a ton of deals with us. So Jonathan, welcome to the show.
Thanks.
Well, so first off, Jonathan, let's talk about what kind of legal issues should buyers be prepared for when they're buying a business?
Yeah, there's a few different categories of issues that buyers should be aware of. And really it's what their own structure looks like, issues with what they're stepping into with the seller, and then just the definitive documents for the transaction. So, first the buyer needs to make sure that they have their own structuring house in order. And you're almost always going to be wanting to buy a business inside of a newly formed company. Typically it's going to be a limited liability company. Occasionally people will use the corporate form. And then of course there's the separate issue of taxation, which you can choose corporate or pass-through taxation inside of LLCs. And then inside of your own entity structuring, is it just a single individual who's going to own it, or is it a few people who are all working together? Are there passive investors? And really, the way you set up your structure will be based a lot on some of those initial questions. And then there's the further question of, is this a one-time purchase, or is the buyer setting up a more complicated structure with a holding company and different branches underneath it? So that's one of the key areas. A second one is the seller structure, and typically in most deals you're going to be buying just the assets of a business. So the buyer's forming a new entity and bringing the seller's assets over. So in that case, whether the seller's a corporation or a LLC and who owns it really doesn't matter as much. Occasionally, a reason that you're taking over the company itself, in which case you need to do a much deeper dive into that area. But another structure that you're stepping into with a seller is just how they've conducted their business. Do they have a lot of contracts? Are there customer contracts? Are there supplier contracts? Are those easy to step into? Are they hard to step into? So just the scope of the seller's legal arrangements with all the various parties they work with are going to matter. And then the third area, and probably the one that I spend my most time on when I'm working with buyers, is the definitive documents for the deal. And there's you're always going to have your primary purchase agreement. You're probably going to have a non-competition agreement. And just what do those documents look like? What's in them? How robust do they need to be? What issues is a seller worried about? How do you allocate risk in between the buyer and the seller? So there's a lot of details that you really need to dive into in your definitive documents. And of course, when I'm talking to buyer clients, one of my initial questions is, what are the key parts of the business? What are you really worried about? And what are the things that you think that we need to cover? Because I know generally what these documents should cover, but every time I always want to make sure that I'm getting, that I'm working on the issues that the buyer cares about and covering the stuff that matters most to them.
Right. And we'll dive into risk a little bit too. too and how to mitigate that. But I think a good point you bring up too is that, there's multiple legal aspects in buying a business. And even when you're talking about documents, like documents, not document, like I think a lot of buyers go in and they think, oh, there's just the one purchase document. But depending on the deal and the structure, like you have to move different assets over. If there's a seller note, those are additional documents. So there's a lot more that goes into the actual legal documents drafting than just like one purchase agreement, right?
Yeah, that's true. The initial document in most transactions is a letter of intent, and that's where you're just figuring out the bones of the deal. Is there a fundamental agreement on this transaction? And then the parties take that and draft a much more robust purchase agreement where you try to figure out all of the various issues in the transaction. And that the asset purchase agreement is by far the biggest document in the transaction and the most important. But there are a number of other ancillary documents as well, as you mentioned. A lot of transactions, especially where there's SBA financing, have a seller carry note that's part of it. And then there's the question of what sort of security do you have for that? Is there a personal guarantee, which can be a separate document? Is there a security agreement in the assets that have been transferred over? So that's often part of the document set. And then, as I mentioned, that you might have customer supplier contracts. So you'll need, depending on the complexity of assignment of those, that you'll need an assignment document with them or an assignment and assumption agreement. Of course, you're probably also stepping into a seller's lease. And so, there's reviewing that whole lease agreement that the seller has or possibly negotiating a new one. And then, other documents with the landlord as well. So, even on a fairly simple transaction, there is a document set. And then as transactions get more complicated, just the length and scope and breadth of all those documents and really the number of different documents you have can also increase.
Right. And it's a complicated process. Like you're memorializing an entire business in a single transaction. So there's a lot to take into account when you're doing the legal transfer. Let's talk about some of the risks and how buyers can best protect themselves from a legal standpoint. So what are some of the biggest risks you've seen in buying a business, and how have you been able to protect that through legal documents or through the asset purchase agreement for the buyer side?
The buying a business can be risky, although obviously everybody wants to do everything they can to minimize that. And so, as an attorney, obviously I'm spending a lot of my time in the legal documents themselves, and I'll get to that in a minute. But I think the number one way that a buyer can protect themselves from risk in a transaction is doing a deal with a seller who they trust. So I think that there's just some front end items of making sure that you that you've met with the seller, that you believe they're doing a good job, that you trust that they've done the right thing. Because if stepping into a business that has issues is a whole lot worse than buying a totally clean business. And there's a lot that you can do just by, as a buyer, using your experience and what you know in order to just initially vet the business and make sure that you're doing a deal with someone who you believe in. And related to that too is a lot of upfront due diligence, that a buyer wants to make sure that they've reviewed the financials and that they know what they say and that they have a general understanding of the business and that they know who the employees are and that somebody's not a major flight or competition risk. And so the more a buyer understands about a business as you're going forward with the transaction, the more you can identify potential risks and protect yourself from them. I think in terms of risks that I've seen on transactions, we do a lot of deals in our law firm. We've averaged closing over 100 deals a year for the past few years. And the number of times that there's any issues post-closing is exceedingly small. So 99 times out of 100, these just work and they're fine. Again, because probably the buyer has done, trust the seller's a good person, and they've done their diligence. Risks that have come up include every so often you'll have an issue with it's really in the broad category of amounts owed to third parties after closing. So occasionally you'll have a business assume a retirement plan like a 401k plan. I had an issue that I saw where there was an underfunding of the 401k plan that had to get addressed. Occasionally on some businesses, you'll see underpayment of sales and use tax. That doesn't come up very much. But when it does, the government wants to make sure it gets its money. So even if you set it up as an asset sale, unpaid taxes can attach to a buyer. And another area where you can potentially have unpaid taxes, and this has been an issue of more significant enforcement recently, at least in Colorado, is the distinction between independent contractors and employees. Mm-hmm. That many businesses over the past 10 or so years have used a lot of independent contractors in contexts where the state believes that they actually are employees. And when the business pays over money to someone as an independent contractor and doesn't withhold the Social Security and other key employment tax withholdings, the obligation is actually on the employer to pay that over to the state. So you could have an issue with misclassified employees come up that could be significant liability after closing. And so there's some structuring items you can do to protect yourself against this type of thing. One of them is, as a buyer, making sure that you have some money in your control that's owed to the seller after closing. And most often in the Main Street and business transaction space where there's SBA lending, there's going to be a note where the seller carries back a percentage of the purchase price. And that's A, often required for a loan, but B, if a buyer owes a seller money, and then it turns out the seller owes some money back to the buyer, we often structure what's called a right of set-off, where if there is a legitimate liability that the buyer has incurred, that's the seller's responsibility, that the buyer can just not pay that amount under the note. Occasionally with longer term notes, there's cash flow crunch issues with that, but that's a really good solution. Another one that you'll often see on bigger deals and you start getting into the lower middle market would be a holdback or an escrow. But you really only see those on deals that you're starting to get over 5 million or so, just because with the structure, it typically doesn't work that way. And a lot of sellers really prefer to not have a holdback, right? The seller wants to get their money up front. And really the promissory note serves as a similar function as a holdback, where it's an amount of money that the buyer owes to the seller under the purchase price that's not being paid right away. So in the Main Street space, you're really calling that holdback. It's really categorized under the promissory note.
Right. And I think that's like, we talk a lot about is like, why would you use a seller note as a buyer if you don't need the money? And I talk a lot about is like, it's not usually about needing the financing for the transaction. It's giving you some sort of control post-transaction if something were to happen with the business. And I think set-offs are a great way to solve for some of these risks that could come up in unpaid liabilities. I mean, you can also structure some of them to protect and risks if there's a big client concentration issue and that client leaves. You can do set-offs, but you can also do adjustable seller notes too, where it can be tied to the performance of the business after the fact. So seller notes give you a lot of flexibility, and your attorneys can really help. Your attorneys and your brokers can help structure and memorialize that deal for you. So great points to bring up, and I agree with you. There really is so few deals in the Main Street space that there are issues that come out. I think, the news talks a lot about these larger mega M&A deals, and those deals always have issues after closing, right? But on the Main Street and small business deals, we rarely see issues. But kind of diving into that, we rarely see issues because people are usually well represented. And this isn't self-serving for us or Jonathan, you at all. But one thing we talk about on this podcast a lot is that if there's any advisor you need in a deal, it has to be an attorney. But just like all advisors, attorneys are not created equal. And we've already talked a little bit about your office does over 100 deals a year. We work with you guys very closely. The breadth of your experience in transactional law is amazing. But if someone's looking to hire an attorney or an advisor for their buy-side deal, like how would they select the best attorney for them for their deal?
And there's a few things that you should look for in your attorney as a buyer. The first, I believe, is subject matter expertise. When you're buying a business, you want to work with an attorney who knows how to buy and sell businesses, and it makes the process significantly more efficient that they've done this before. But there's also a lot of issues around making sure that, well, when a buyer comes to us, we have the expectation that they want to buy the business and that they want to do the deal. And we've done so many deals that we know how to get to closing in a way that protects the buyer and is reasonably efficient. So having done a lot of deals, you know what appropriate terms are, where to start, where to push, and it just really helps the deal get done. some of the biggest issues that we have is when we're on a transaction and someone else in the transaction is using an attorney who maybe specializes in litigation or in family law or estate planning. And these are often smart people who are great attorneys, but they just don't have the reps in this space to start with documents that make sense or to revise documents in a way that's appropriate. And there's also a big part of this is that there are market terms for these transactions. And maybe on occasion you'll have a deal that should be outside of market terms for whatever reason, but there's really some guardrails on what your documents should look like, what you should be asking for, what protections are reasonable, what a seller should be, what representations and warranties a seller should be making. And an attorney with subject matter expertise who does a lot of these deals knows a good starting point, knows a fair ending point, and knows how to get there. And if there's an attorney in a deal who doesn't know that stuff, I've on occasion had to spend hours, which can really add up for a buyer, educating the other attorney on what appropriate terms are or how these matters are handled, or even worse, you can get an attorney who enables a party to take an extreme position that is not appropriate for that transaction, that really forces the buyer to reconsider the deal because the risk allocation is just so unreasonable for them. It happens very rarely, but I've seen that with some attorneys who really don't have experience in this space. Another issue is style alignment, that there's different attorneys and different business parties just have different styles about how they approach a transaction. And there's some people who are soft-spoken. There's some people who are loud. There's some people who really want to start with aggressive terms because they just want to protect their client as much as they possibly can. There's others who are focused on getting a deal done and are much more willing to just start with reasonable terms or get to reasonable terms right away. And I think it's important for a buyer to understand what they're looking for. Are you the type of person who really just wants to get a deal done as efficiently as possible, or are you the type of person who really wants to make sure that you're getting the best terms for yourself? And do you want to push really hard and potentially alienate the other party in order to improve your terms in a way that is best for you, or are you willing to compromise, and how do you want to do that and when? And so a lot of attorneys have different styles on this, and I found a lot of business buyers have different styles on this too. And certainly attorneys are flexible and it's their job to advocate for their client, but I think it's important to think about how you want to approach a transaction and how you approach negotiations, and finding an attorney who aligns with that. And then the last big piece is experience in the market segment. There's M&A attorneys who work on, who generally work on deals that are below $1 million. There's attorneys who work on deals that are in the seven figures. There's attorneys who work on much bigger deals. And experience on $100 million deals is certainly helpful, but an attorney who works on a $100 million deal is probably going to bring in more robust forms and a different approach to $1 million deal, and you might end up paying for that expertise and that more robust scope of representation. And part of it is on bigger deals that there's just so much more money at stake that it can be worth a bunch of money to dig down into every last single issue. And a lot of attorneys who do work on much bigger deals, that's just how they are structured, and that's how their law firms are. Whereas if it's a deal that doesn't quite have as much money at stake, you obviously want to be protected by your attorney and have good documents. But it's all the people who work on smaller deals know to focus on key issues, and that running down every last piece of due diligence is maybe not the best use of significant attorney time. So know the size of your deal and find someone who has experience on that size of a deal, and a law firm that has experience on that size of a deal.
Yeah, I totally agree with you. I think, the expertise one, we always compare attorneys in these deals to like surgeons, right? You don't want your cardiologist to be replacing your hip. And it's the same thing as like family law and transactional law, very different segments of the industry. And likewise on the size too, because I think sometimes people are surprisingly shocked how I wouldn't say that legal advice in these size deals is inexpensive, but it's not as expensive as you would think, because there are firms like yours that specialize in the Main Street to lower end of the lower middle market, where you're not paying,
tens of thousands, hundreds of thousands of dollars on attorneys, right? Because there's a different legal set and there's different types of representation for $100 million deal versus $1 million deal. So I think all great points. Jonathan, I thank you so much for coming on and sharing your expertise. You provide so much value to our office and our network. If someone wants to get in touch with you for further questions or to work on a deal together in Colorado, how would they reach you?
Yes, I'm best. I can be reached either by phone or by email. Our main office phone number is 303-850-7080. And I'm always available by email as well. It's Jonathan, JONATHAN @izbikylaw.com. And the latter part is spelled I, Z as in zebra, B as in boy, IKYLAW.com.
Great. And we'll drop that information into the show notes as well. But Jonathan, thanks again for joining us.
Yeah, thank you.
Hey, Andy, do you know what time it is? It's time for our deal of the week.
Deal of the week.
Sold.
Welcome back, everybody. And today for our deal of the week, I'm joined by Al Fialkovich, the co-owner and managing director of Transworld Business Advisors in Colorado. Al, welcome back to the show.
Jessica, thank you so much for having me. It's good to see you.
So you recently closed a business in the janitorial industry. Tell us a little bit about that business.
No problem. So this was a great business that had been rock steady for years. They had been in business for over 30 years.
Sounds like a good business. And who was the buyer for this transaction?
The buyer was another janitorial company, a company that was actually a little smaller. That we had multiple bids on this deal, and they're basically going to more than double their size with this acquisition.
Sounds like a perfect growth opportunity for the buyer. So tell us a little bit about the numbers. What did the business sell for? What was the multiple? How was the transaction financed? All those good details.
The business sold for north of $3 million. It was an SBA loan, a little bit of seller carry, and mostly cash at close. The multiple was about a little north of 3.5.
Good value on that business and good value for that seller. So if anybody is looking to sell or buy a business in the janitorial industry and would like to talk to you further about their transaction, how would they reach you?
The best way to reach me is phone 720-357-6853 or email al@tworlddenver.com.
Great. Well, thanks for joining us on the show, Al, and sharing us this deal.
Great to see you.
Hey, welcome back, everybody. And we are again talking about what to know legally about selling your business, kind of talking about it from the sell side. And I have my dear friend and amazing attorney that's been doing deals with us longer than she wants to admit, Deborah Carman from Carman Law Group and Firm. And Deborah, welcome to the show again.
Thank you, Andy. It's great to be on here again. And I've been doing this for almost 37 years now. So I've seen a lot of different things happen with sellers and a lot of things we can share with them so they can prevent it and have a very smooth closing.
Yeah. And so let's just start out by saying you need an attorney to close a deal, right? Why? I've seen sellers say, oh, I don't need an attorney. Let the buyer have an attorney. Why does the seller need an attorney?
It's interesting to me that you bring that up because every time I turn around, a seller says, well, I can just give them a bill of sale. It's very easy to do. We're going to shake hands. We're all going to have a nice honeymoon together. And they don't even realize some of the intricacies that are involved in a business transaction. So it's the same thing that we find over here. You know, we have a title company as well, and people say, well, I don't need an attorney. I have a title company. And it all becomes the same thing. Do you want to make sure that you understand 100% what you're signing and getting into? Do you want to have someone that is there to protect your interests? Or do you want to really be on the other side of another attorney who is looking out for a buyer and not looking out for you? And this is your business. This is extremely important to you. You've spent a great deal of time to develop this business. And what I find after all these years is that sellers, this is their baby.
Yeah, it is their baby.
They put a lot of time, a lot of interest. And that brings you to some parts over here about what you do over at Transworld is finding that right buyer for them. And that's so important for them because people realize that they've spent this much time. They don't want a buyer to come in and really give an issue to their business that they spent all this time developing.
Yeah.
And of course, they want to be paid.
Yeah, they want to be paid. But the second half of that is they're trying to get rid of a business, right? And for the years you've been taking risk as a business owner, and so you don't want that risk to continue. So I always look at it and say, listen, you want to make sure that you transfer those assets properly, and the buyer has full control and is now liable moving forward, right?
You really want to make sure you do that, not just on the business, but on the lease, on other contracts that you might be assigning to them. You want to take that responsibility, and you want to be able to sleep at night. Once that business is sold, you don't want to have to worry for the next 10 years, 5 years, 7 years, wherever it's going to be, that there's going to be an issue. It's going to wake you up in the middle of the night. You're going to have to hire an attorney here for litigation purposes. Right. So you want to really have someone that's looking out, protecting your interests, and making sure here that if there's financing involved, you're going to be paid properly. It's going to be collateralized property. If there's something involved over here, even in something like a non-compete, that you're going to have it done properly, so you're not going to be in competition or be in breach. And that's a whole other consideration people have as well when they sell their business. What am I doing here? Am I selling all aspects of my business? Is there some part that I want to keep? Is there something I want to carve out of a non-compete so I can continue here? Maybe in an air conditioning business, I want to be an inspector. I don't want to compete with you directly, but I want to have an ability to still earn a livelihood. I don't want to have to retire totally. And then there's some people, Andy, that just want a job.
Right.
They bought the business because they want a job, and now they're selling the business, and all they want to make sure of is that they're not going to be fired, and that they have an agreement here that's going to pay them for all their expertise, but they don't have the headache of running the business on a day-to-day basis.
Yeah. And we've certainly seen that where sellers want to stay on either as a consultant or an employee, or they, like you said, they want to do something else. They want to go teach. They want to go consult. Right. And if you violate a non-compete and you have a note out there, you're probably not going to get paid. I mean, it becomes a war, and that's certainly
It really does. It really does become a war. And it's not something you wanted to do initially. You didn't, figure it out. You didn't think about it properly. And I always refer to this kind of the honeymoon stage of people. Everybody's very friendly together initially. And then as time goes on, you realize that there are nuances between buyers and sellers, and that they don't get along as well down the road in many cases. And you want to have legal protections in place. And if you don't have those legal protections in place, you're leaving yourself really in a naked and vulnerable position.
Right. And you listen, there is some risk in selling your business. You're not going to be able to get the money. You're probably not getting all your money. Even if there's an SBA loan, there's usually a seller leave behind. If you have to owner finance it, you have to leave behind. You're probably going to have to stay on the lease, at least for the initial term of the lease or the remaining term of the lease. But again, having the proper representation is going to help you minimize those things, right?
Exactly. And what we call that is also not just representation, but proper documentation. And that's what really is involved here, is to document your entire transaction so that it really fits your transaction and also fits what your requirements and your needs are. If there's SBA involved, there's different types of documentation you have to understand there. As a seller, you have to understand all different aspects of forms and agreements that you've signed in the past. People don't realize, too, that many times they sign contracts and they don't transfer. They're not assignable. But a seller doesn't think about that. And sometimes that leads us to not an asset purchase, but a stock purchase, just to go ahead and accomplish what the seller needs.
Yeah. And talking about accomplishing what you need and making sure that there's the proper paperwork, it really is important to have an attorney that knows what they're doing, right?
I agree 100%. I have seen now litigation attorneys. I have seen personal injury attorneys. I've seen probate attorneys. I work with all aspects, all types of attorneys, because we want to get the deal closed. But it's important for you to feel protected. And for you to be protected, you need to have an attorney that handles business transactions. And it's a really important difference. I see people who do real estate only, and I do real estate as well, but they don't understand what it is to take care of a business and to properly document that sale. I get the weirdest documents I've ever seen from someone that doesn't practice in business transactions. It doesn't protect you as a seller.
Right.
And that's really what you need. Plus, you really need help and guidance. And that's what we do, too. Just like you have a good business broker, and I know at Transworld you have the best, over at our firm, we do a lot of guidance with you, a lot of counseling with you, because it's important for you to know exactly what you're getting into and what you have to do to protect yourself down the road. Even something like insurance. I've seen people, give you an example of vehicles. When they transfer a vehicle, they don't think about, what do I need to do with the insurance? I'm not taking care of something, maybe is there training involved, and I'm not going to have an effective date of a transfer for 2 or 3 more weeks. I have to keep that insurance on that vehicle. It's got to be done properly. Something is people don't realize too that you have to have named insureds. If you're going to be there as a consultant, you want to make sure that you're properly insured. So if anything does happen with that new buyer, you don't have a risk. And people don't think about everything. That's what we do. We're paid to think about and make sure that all bases are covered. And that's really what we do.
Yeah, and the other thing that I want to kind of highlight, and we were talking about this before we got on started recording, was that the sellers really need an advocate, but they need to be honest with that advocate, right? They need to come forward because there's a lot of things like tax liens and perhaps hidden litigation or pending litigation or threatened litigation that they have to come honest. They have to be honest up front.
They really do, and people have to understand that when I represent you as a seller, what you say to me is in confidence. And you have to give me all the skeletons in your closet for me to protect you. If you leave a few of them out, they're going to come back later and potentially bite you. I am here to make sure I know everything about your business, everything about any liens that you do have. Sometimes you have to take those liens and you actually have to work to get them down to a level where you can sell your business. So I need to know what really is out there. I need to know if you've had problems with employees. I need to know if there's potential litigation coming in. I need to know if you are in litigation now. And I really need to know as quickly as possible, because when I have a buyer right now, and most of the time sellers don't retain you until there is a buyer. Right. I only have a certain amount of time to take care of everything or the deal is going to fall. And I know, time kills deals, and the more time it takes me to fix an issue, then that becomes an issue then for a buyer to stay interested in that deal.
Yeah, time does kill all deals. And we have a certain amount of time to close these deals before people lose interest and banks lose interest. I know your husband is also a banker and a specialist in SBA loans. So he even knows that, when we're trying to put all these moving pieces together, it's really important for the seller to make sure that they understand legally what's going to happen. And it is part of telling the story and warning them that there is some liability post owning a business. But that's what you're getting paid for, right?
Exactly. We try to minimize that, and we try to educate our sellers. Some sellers say to me, for instance, that I have a right to work. It's a right to work state. And I have to explain to them that when you sell your business and you have a non-compete, you cannot compete in that industry for the amount of miles you're restricted for. And people have a hard time sometimes wrapping their head around that. So everything has to be explained. And sometimes there's that rogue family member, Andy. And that rogue family member is the one you have to kind of keep an eye on, because they cause an issue, not only with a non-compete, but sometimes there's an issue even with employment. I remember one deal we had where the brother-in-law had to actually sign off, and it was a very difficult transaction. He couldn't stay with the business, but he'd been with the business for many, many years, and he had to sign off.
Right.
So people have to think about everything when they go to sell the business. And it's something that you've got to be very careful with. Even if you have a son or a daughter that's in your business right now, many times they're also going to be asked to sign a non-compete.
Yeah, I mean, listen, we're trying to do good deals for good people. So the buyers, deserve the right to be protected as well. And it needs to be a fair deal. And so that's why you need good representation. And so you did a great job of kind of laying this out. We'll probably have to we'll get you back on to talk about the buy side eventually. But thank you, Deborah, for coming on today. I really appreciate all your insight. Hey, if someone wanted to get in touch with you, what's the best way to do that?
The best way would be to give me a call at our phone number of 561-392-7031. And thank you so much for having us, Andy. There's so many things I didn't even get to mention really about sellers and about protecting them and taking care of them with landlords. But each phase of this deal, there's a lot of items that need to be taken care of to protect the seller.
Yeah, and there's a lot of paperwork involved. So thank you so much, Deborah. I really appreciate it.
Thank you, Andy.
Hey, Jessica, you know what time it is?
Money time?
Almost. It's time for listing of the week.
Hey everybody, we're back, and it is listing of the week, and we have a very interesting listing. We have Tom Milana here from Transworld Business Advisors of South Florida. Welcome back, Tom. Tell us a little bit about this. This is an interesting one.
Yeah, Andy, thank you. Nice to be here again. Andy, we have listed a mine. This is a 640 acre or 1 square mile property located southeast of Fort Myers. Since 2003, it has been a sand and gravel mine. There's also a DOT grade of riprap. Riprap is the aggregate, the small rocks that they pull out of the mine. The property, according to its appraisers and environmental inspections, have about 8 million tons of sand and fill and about 6.5 million tons of rock reserves available. And like I said, this property is here in the South Florida area, just southeast of Fort Myers. And we have an asking price of $15 million.
Yeah, it sounds like a good deal. I mean, listen, they're not going to stop building anytime soon in Florida, right?
No, not at all. Although you would consider this property kind of in the middle of nowhere. It is off of one of the major highways off of Alligator Alley. It's north of Alligator Alley. And the overall property is zoned as a PUD. So eventually, maybe 20 years from now, it'll be a community. But right now, it's a great opportunity that for someone wanting to get into the aggregate mining business.
And they have some equipment still, right?
There's approximately $1 million worth of heavy equipment on the property.
And did we say what they were asking for it?
Yeah, the asking price is $14,999,999.
There you go. Just under $15 million.
Yes, sir.
So it's a great listing. Certainly something that someone might want to do a real estate play or understands the mining business. Tom, what's the best way to get in touch with you?
Yeah, it's Tom Milana at tom@tworld.com or 561-702-6867.
Perfect. Thanks, Tom.
Thanks for tuning into the show today. If you like the podcast, share it with your friends on social media. And don't forget to subscribe and leave us a review on your favorite podcasting app. If you have questions, would like to appear, or have suggestions for topics for the show, get in contact with us through our website, thedealboardpodcast.com.